Hi everyone, it's Rob Ryder on Sunday, November 27th, 2016. Going to switch gears a little bit here. The last number of videos have been on mortgages and trying to find the securities, which are actually yours. It was an investment contract, and the piece of paper that we would call the title deed, the legal title, so that the legal title has your name on it to show that you are the legal owner. But it's just one of the things I do in this search for an answer, and the other one is what this is about. So it's dismissed by administrative means, an alternative to motion practice. So in other words, keep it out of the court, do it administratively by using documentary evidence of corrupt practices to compel those in authority to administer a remedy, and how to improve upon its execution, which is what I'm most interested in, having done the other part. So I'm going to show you a couple of cases that I've been involved in over the last couple of years that in a number of things that were done. One was to send a letter to the chief judge, pointing out that they were simulating a legal process, basically, in the courtroom. And, in both of those cases, these cases have been dismissed. One was for basically an ordinance violation, disturbing the peace, but it had escalated to a $3,000 bond and possibly going to a mental institution and things of that nature. And the other one was a misdemeanor felony, felony gun charge, right? Having a handgun unloaded, but with a full magazine in the passenger compartment of a car. And it was recently dismissed also. And so, not really know where to start with. I'm going to start here because this is going to be tied to the military before I'm done, and so I just get my stuff out of the way right off the bat. So what I plan to do to improve it next time, because like I said, it was writing a letter to the chief judge. I'm going to write the letter to the chief judge. I'll probably still send it to the chief judge, but I'm going to do it on this military sworn statement form from the Army, because I'm going to make the case that, hey, we're under martial law, so don't argue with it. Use it to your advantage. And so if you were to Google military sworn statement, you would find this form, I'm sure. And there isn't much you need to do. Put your name, want to make the following statement under oath. Start talking. Now, I will say this, it says last name, first name, middle name, and normally I would say, well, I'm not going to do that. But that's when it says name, and then parentheses it says last name, maybe middle initial or something like that. Well, I don't want to do the stuff in parentheses, but because they're asking specifically, put your last name and your first name and your middle name with a comma. Well, I do it just like it shows right there. Now, my status, I could say I'm a veteran. I could say I'm an E6. I could say I'm an elector. Right? So you could be an elector, right? Pick that one. Highest office in the Constitution. You can have exhibits, right? So as we're going to see, we're going to complain about their paperwork. So that might be your exhibits to attach to this document. And more blah, blah, blah. And then the last page, and this is why I'm so compelled to use it, is because when you do this affidavit, so I have read or have had read to me this statement, which begins on page 1 and ends on page whatever. I fully understand the contents of the entire statement. Man, they just make it doesn't quite fit. Made by me. Excuse me there. By me, the statement is true. I have initialed all corrections and have initialed the bottom of each page containing the statement. I have made this statement freely without hope or benefit of reward, without threat or of punishment, and without coercion, unlawful influence, or unlawful inducement. And you're going to sign it before somebody who is authorized to, by law to administer oaths, and 2 witnesses. And so this takes care of the biblical scripture that says, establish all words before 2 or 3 witnesses. You will if you use a military sworn statement. And so this has a number on it. Let's just get down to the number, right? It's DA Form 2823. You may want to Google it and just put it in your computer for future reference. Okay, so there you go. It didn't say it had to be done by the military. In fact, when you read this Army regulation that goes with it, it falls under Title 10, United States Code 301, Section 5, Title 10, USC 2951, and EO, blah, blah, blah. Anyways, I believe it talks about even minors doing this. So, there you are. If you're going to swear to it, say it's the truth. You can even do it as a minor. And so that would be the form I would do what I have done prior to, and I might word it different knowing what I do now, but the idea was it wasn't put into the court case, it was sent to the chief judge. And so next time I'll send the chief judge one of these and see if it makes him do anything different. And so that's the form. And because I'm going to make the case that we're under the Lieber Code, which is right here, martial law. So here's the instructions for government of armies of the United States in the field, called the Lieber Code, from 24 April 1863. Article 2, martial law does not cease during the hostile occupation, except by special proclamation ordered by the Commander-in-Chief, or by special mention in a treaty of peace concluding the war, when the occupation of the place or territory continues beyond the conclusion of peace as one of the conditions of the same. Blah, 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 blah. So basically, once martial law has been invoked, it can only be uninvoked by a proclamation from the Commander-in-Chief or by having it put into a treaty of peace. And neither of those have happened since the Civil War, which was never a declared war. It was always an insurrection and rebellion, and it still is, and it's still going on, and we're still under martial law. And you can read about these kind of things. I'll try to find the article that I'm going to read, that I read it from, that basically says, once Lincoln declared martial law by order, soon after the Congress passed an act to I do a habeas corpus. What's the word? Not rescind, but something along those lines, And then the war continued. Well, at the end of the war, these military governments that had been established under the Lieber Code, they didn't want to give up power, and so they didn't. And there's never been a special proclamation or any treaty of peace to conclude the Civil War. And so we're still under martial law. Now, under martial law, right, so if you've never read the Lieber Code, you might want to go pull this out. It's called the Lieber Code. And I'm not going to read the whole thing, but let's read a few. So here in Article 6, all civil and penal law shall continue to take its usual course in the enemy's places and territories under martial law, unless interrupted or stopped by order of the occupying military power. But all the functions of the hostile government, legislative, executive, or administrative, whether of a general, provincial, or local character, ceases under martial law, or continue only with the sanction of, if deemed necessary, the participation of the occupier or the invader. And I've pointed out, I don't know how many times, just countless times, all you got to do is look at these people's paperwork when they say they've been elected. They don't have a certificate of election. They don't have a certificate of appointment. They don't have an official oath. They don't have an official bond. And they're using a pseudonym. They're not using their proper name. They're not lawfully elected by the laws that you think that they would have been elected by. We just went through an election, and if you look in Article 2, the very first sections of the Article 2 of the U.S. Code, like Section 1 to 30, it will tell you in there what the senators and congressmen have to do prior to taking a seat to be considered seated in government, and they're not doing it. They don't have a certificate of election under the seal of the governor from their state to go and give to the secretary of whoever they are and present their papers. Right? Hey, I'm the new representative from wherever. They don't do that. But this says that the laws are still supposed to take their own course. Now, if habeas corpus is suspended, that's the word I was looking for. Let's just real quick look at that. Right? Literally means you have the body, whereby a person can report an unlawful detention in prison before the court, usually through a prison official. Well, that would be, Roe just told me the other day, where is the U.S. prison place in a state? It's has the same address as the military's in processing address. I have to look into that more. But anyways, a writ requiring a person under arrest to be brought before a judge or into court, especially to secure a person release unless lawful grounds may be shown for their detention. So in Michigan it says that courts of record have jurisdiction in criminal matters by information and indictment. That would be an MCL 767-1. It goes on to say that the style of process for courts of record, which are, right, the courts that have jurisdiction in criminal causes, by information or indictment, shall be in the name of the people of the state of Michigan. That's who the plaintiff should be. If you got a loved one that's in a criminal case, well, that's who the plaintiff should be in their criminal case if it's being done in a court of law or court of record in Michigan. It would say, in the name of the people of the state of Michigan. That's the style of the process. And it don't say that on paperwork. And also, MCL 600-1416, Court of Record seals. The following courts are courts of record and possess seals. Supreme Court, the several circuit courts, the probate courts, the recorder's courts, courts of claims, any other court the legislature designates as courts of record. And so here I believe those would be our district courts even. Right? So, how do you know if you've been to court? Well, there would be a court seal on your paperwork, because that's what courts of records use. And that's another thing I've pointed out numerous times, is they never use a court seal on your paperwork. All they ever have is a clerk's stamp, but not a court seal. Where is the court seal? Well, if there is no court seal, then you haven't been to court, and therefore habeas corpus is suspended. They're just not telling you. They don't have to tell you. That's the thing about military law. Article 1. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to its inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. We are still in an insurrection and rebellion since the Civil War. And then in those courts that we go to, everybody talks about the gold fringe flag, which is there, but then they want to say it's the Navy. It's not the fucking Navy, it's the Army. That's called the national color. That's the Army's flag. It's what an Army color guard guards, is the flag that you saw hanging in high school or in school with a gold fringe on it. And so if that flag is there, then the Army's in charge. Or it's a war trophy and those people are involved in an insurrection. Either way, the Army needs to know, because they'd have to go recapture the fucking flag. Martial law affects chiefly the police and collection of public revenues and taxes, whether imposed by the expelled government or by the invader, and refers mainly to the support and efficiency of the Army, its safety, and safety of its operations. Right? So, if you're under martial law, then all administrative functions have ceased. However, the courts are supposed to operate under the penal laws of your state. But they're not using a court seal. And so, if they're not using a court seal, then it's under the Lieber Code that this is happening. And if they're not following the laws of the state, you go and tell the Army. And I think that's what the chief judge's job is. They're the chief administrator of the court. The law of war does not only disclaim all cruelty and bad faith concerning engagements concluded with the enemy during the war, but also the breaking of stipulations solemnly contracted by the belligerents in a time of peace, and avowedly intended to remain in force in case of war between the contracting powers. It disclaims all extortions and other transactions for individual gain, all acts of private revenge or connivance of such acts. Offenses to the contrary shall be severely punished, and especially so if committed by officers. Yeah, there you are. Because of Article 11, that's why you would take it to the chief judge on a sworn statement. And then, hey, if they won't do anything with it, well, then I'll take it to the armory. But I'm just saying, I'm going to take it to the chief judge because, hey, that's had an effect in the past, and we're going to get to that in just a second. But hey, guess we're talking about Army stuff. For all you Army people out there who have one of these, right, DD-214. So here's mine, right? So I was in the Army. E6, spent 8 years in, made E6 in 5.5, well, less than 6 years. Our people tell you that's pretty damn fast. But what I really want to show you is look what they do to us, right? First of all, they put our name. Here's the thing I don't like. Name, parentheses, last, first, middle. And then sure enough, there's our name. But that isn't my name. My name is Robert Allen Ritlewski. They got me to put my name backwards. And they do this in all sorts of paperwork, so you've actually served under an assumed name. And that would be covered under 10 U.S.C. 1551 and 1552, that you can, in the military, serve under an assumed name. And so for that reason, that would allow all these attorneys and judges and so forth to use a middle initial if they were actually officers working for the military. They can be civilian officers, right? They don't have to be in the military. They just have to be working for the military, to be under military control. And then there's this piece of paper. So here's an honorable discharge, and this is what I want to point out because they've done this to everybody who's served in the military. On an honorable discharge, if you look at separation documents, Army Regulation 635-5 for the DD Form 256A Honorable Discharge Certificate, it says, issue these discharge certificates appropriately to all soldiers receiving honorable or general discharge. In the space under, this is to certify that, enter the name, typed in all capital letters in signature order, followed by the grade and career branch if an officer, or grade and component if enlisted. Do not include soldier's social security number. How much you want to bet they didn't follow the law? Let's take a look. Well, there's my name in all caps, but that's not signature order. Although they say it is. They didn't put the comma here, right? So they're saying that's the dude that served. And it does have a social security number, and we just read that it's not supposed to have a social security number. And it's supposed to have the grade and the unit you served in. Well, USAR is United States Army Reserve, and I wasn't in the Army Reserve. I was in a regular Army. This should say RA. So there you are, right? Let's go look again. Enter the name typed in capital letters in signature order, followed by the grade and career branch or component. Do not include the soldier's social security number. And yet, there's a social security number. And there's my name backwards. They're saying that that's how I served under an assumed name, Rutluski Robert Allen. So I'm going to use this same idea. The reason I'm showing you this, I'm going to use the same idea with the... I'm just trying to find the right form to bitch on, and I got all sorts of complaints. Well, this would be one, right? That if you're in the military, or we're in the military, we're not getting our entitlements because they had us serve under an assumed name and the records haven't been corrected yet. It's really that simple. Okay, enough on the Lieber Code. Right? I'm just, again, I'm saying because of number 2, that martial law does not cease during hostile occupation except by special proclamation ordered by the Commander-in-Chief or special mention in the Treaty of Peace concluding the war. Please find me one of those from the Civil War, and I'll agree that martial law is probably no longer in effect. Until you do, well, then you'll have to agree with me that it is, because that's what the law says. And if it is, then don't run away from it, run towards it. Right, that's Caesar, right? Caesar doesn't care. He's going to just carry out the law. You want to be a citizen of Rome now. If that means be a citizen of the United States because the United States Army's in charge, then so be it. Okay, let's look at let's look at this real quick. Just to show you, right? Here's an Army color guard, and they got gold fringe flag. The image is too big. Shoot. I forgot about that. I'm going to have to show you. Bear with me a second. And all of this is covered in Flag's Guide on Streamers about flags, right? So if you really want to know about a flag, go get yourself a copy of Army Regulation 840-10. And let's look at color guard. G-U-A-R-D. Color guard. This would be in Wikipedia. There'll be some Frenchies. Old stuff. Guys with big beavers on their heads. Ah, there's the Army. Hey, they have a gold fringe flag. And these would be the Marines. And that flag to me doesn't look like it has any gold fringe on it. And the Marines are the Navy's land force. And so, what is the Marines carrying that? Oh, here we go. Right, the Marines don't have gold fringe on their flag. There are other flags that got gold fringe, but not the U.S. flag. Who has the gold fringe? Not the Navy. But the Army does. And when it's like this, it's considered the national colors when the Army's carrying it. And so in this book, or in this regulation, it says it's authority for these. It is the authority for these items and their basis of issue. It also describes the flags used by the President, Vice President, officials of the Department of Defense, Chairman of Joint Chiefs of Staff, blah, blah, blah. Responsibility. Okay, here we are. Unauthorized use of official flags, guidons, and streamers. There is no law that permits the sale, loan, donation of flags, guidons, streamers to individuals or organizations not in the military service, except as indicated in 1 and 2 below. 1 is educational institutions, and 2 is retired generals. Otherwise, you had better be under military service or included in military service to be flying an official flag. The President of the United States, he gets the national flag. But all these people get a thing called the national color, which is the United States flag with a gold fringe on it. So when the president has a gold fringe flag in his office, it's him as the commander-in-chief, not as the president of the United States. The flag of the United States is a symbol of our nation. Period. The flag of the United States will be displayed outdoors all times at all Army displayed outdoors at Army installations. And national flags listed below are for indoor display and for use in ceremonies and parades. For the purposes of the flag of the United States will be rayon banner cloth, heavyweight nylon, trimmed with 3 sides with gold, yellow fringe, 2½ inches wide. That would be the national flag, displayed indoors. Well, that's the flag that the Army is supposed to defend. So then it gives these different sizes, and it says here, it will also be displayed within the offices listed in C below when no other positional or organizational flags are authorized. Authorization for indoor display. The flag of the United States is authorized for indoor display for each office, headquarters, organization authorized a positional color, distinguishing flag, or organizational color. Military offices not otherwise authorized an indoor flag. Military courtrooms. Hey, military courtrooms have gold fringe flags. Wow. But so do other offices authorized, offices, headquarters, and organizations authorized a positional color, distinguishing flag, or organizational color. Now, a distinguishing flag, I don't know if that could be like the Michigan flag that they have flying, the other flag they have flying in the courtroom. Is that a distinguishing flag or organizational color? I'm not really sure. I know sometimes you see it by itself. Well, it sits by itself. They may have other flags in the room, but it's sitting over here by itself. So, there you go. The gold fringe flag is in the courtroom. The gold fringe flag is used by the military. The gold fringe flag is what the color guard is supposed to guard. And under the Lieber Code, any solemn agreement that's already been signed is supposed to still be in force, and that would be the Constitution. Because, it's the North and South fighting over the Constitution. And the Army's job is to defend the Constitution. In fact, that's what General Dunford had to come out here and say just before the election to the military. Your duty's to the Constitution. Which means it isn't to Obama or to Trump, it's to the Constitution. So we're going to fire that up. See if it works. So enough on all that. Let's get on to why we are here. Why are we here? Because I wanted to show you just the level of corruption of the paperwork, number one, they put in, and then, by the grace of God, throwing enough garbage at people, finally got something to happen. So let's go from older to newer. This was what happened to Rosita over in St. Charles in Illinois when she had gone to the clerk's office and asked maybe one too many questions, and all of a sudden the clerk makes a phone call and their sheriff's officers want to escort Rosita to the jail. Because apparently she knowingly and intentionally alarmed and distressed Sandy Wegman in such an unreasonable manner as to alarm and disturb Wegman and provoke a breach of the peace. That's all it took to get arrested. Under Gen number 13-12026. Gen, hey, I wonder if that stands for general. You think? So anyways, this kind of started Rosita's, her own little trials and tribulations she had. But as we found out later, this form is well outdated, and it wasn't filled out properly, and all sorts of things happened, but it's what they used to initiate a court case against Rosita, which led to this being created before she could get out of jail, which was the same day. She had to sign this. And the court calls it a certificate of defendant. In fact, that's the way it shows when you go look up on the look the docket up as a certificate of defendant. But this isn't a certificate of defendant. This is a bond. Now look, they didn't put the case number. Go figure, right? This is where the deceit starts. So now they're going to get you to sign a bond, and they're not going to put a file stamp to show it was ever put into court. But what Rose said is when you went into court, the judge, all she was doing at that court hearing was pointing to your signature and saying, is this your signature? That's all she wanted to know, yes or no. We should see what that means. If you said it was your signature, it means that I, the defendant, named above, so number one, you just agreed to be the defendant named above, and you agreed to be the defendant named above as last name, comma, first name. Do hereby state that I know and understand the terms and conditions of this bail bond, so it's not a certificate of defendant, it's a frickin' bail bond, as shown on the front and back of the attached to this bail bond form. I acknowledge that I have received a copy of this bail bond. I understand further that if at any time prior to the final disposition of the charges I escape or am released on bond and fail to appear in court when required by the court, the result will be as follows. I waive my rights to confront the witness against me. The trial can proceed in my absence. I forfeit the security money posted. Judgment will be entered against me for the full amount of the bond plus cost. A warrant may be issued for my arrest, in which events additional bond may be required. I, the undersigned defendant, do hereby acknowledge myself to be indebted to the people of Illinois, or the city or village set forth as the municipal corporation, in the sum indicated as bail. I have deposited the amount set forth herein, and I, the undersigned defendant, acknowledge the conditions of this bail that follows. You've self-confessed. Once you become the defendant, you agreed that you committed the crime. Right? I'm not the defendant. I'm here to protect my interest, but I'm not the defendant. On a bail bond, where you just agreed that whatever amount they put in, and so they said $1,200, well, Rosita just agreed that she's indebted to people of Illinois for $1,200. Well, who the frick are the people of Illinois? Because up here it was the people of the state of Illinois that's supposed to be the plaintiff. Right? But down here it says people of Illinois are the one that she's indebted to. So Rosita's confessing to the court that she owes this thing called people of Illinois $1,200. Right? Now that's just as corrupt as can be, and any police officer that allows themselves to be involved in this, I'm afraid you're going to be driven like a tent peg, right? Because you're the people whose names are on this shit. You can't allow yourself to be put into harm's way by these frickin' attorneys and attorneys acting as judges who really aren't judges because they don't have a certificate of election. They don't have a certificate of appointment. They don't have a proper oath of office. They don't have an official bond. They have none of these things required under your state's law for them to enforce the laws of the state. They're just simulating that they do. And so if they have any authority at all, it came from the military, because they do have an oath. It just isn't the oath that's called for by your state law to hold the office of a state officer. So that isn't the office they're holding. Then they must be working for the military, because we're under martial law. And, this is what's happening downstairs, and the guy upstairs doesn't know because no one's ever brought it to him in his right hat to say, hey, this is what's happening in your courts that are supposed to go. The courts are supposed to function using the laws that were written, but not necessarily the officers who, by the law of the state, would be there to enforce them. Because all that shit's been suspended. Civil law has been, or your civil rights have been suspended. It's now we need to be protected by the military because we're the peaceful inhabitants. We're not the belligerents. Okay, so this just gives you an idea. I mean, this is the corruption level. There's no court seal. There's no court number or case number. They're getting you to sign saying that you're acknowledging you owe this money without any reason for owing the money, just that you do. There's nothing on here what you did wrong. It's your unilateral contract of gift or donation. Okay. Well, we went on a little bit longer in time. This is all back in 2014, right? But well, apparently Roe missed a hearing or something, or didn't show up, or whatever. This is early on. We're trying to figure out what to do. And they come knocking at her door and say they have an arrest warrant, which was filed. Clerk of the Circuit Court, Kane County, Illinois. Right? So this stamp looks different than most stamps, but this isn't a court stamp or a court seal. This is a clerk stamp. So where's the court seal? I'm not even sure it needs it, but I'm pretty sure that it does. But anyways, right? So now we're up to a $3,000 bond, right? So this thing that started as disorderly conduct for asking, one too many questions, and not at all belligerently, just asking questions that the county recorder didn't have answers for. Like, why are you charging me this when the law says this is what I should be charged? Why are you taking $10 that the law says is charged and charging me $10, but charging $9 to this and $1 to this instead of $10 to the thing that the law said to charge it to? Well, that's disturbing my peace. Boom. Next thing you know, they extorting money. And so, anyway, because, all these were over some period of time. Like this thing is, what was this, did I say? This is in January 2014. So we tried all sorts of things for over a year till we got to the point where here in December 2014, we're finally getting around and decided we needed to do something different, because now by this point they're talking about involuntary incarceration for mental health issues, and had to go have an evaluation, all that crazy stuff that they say you have to have done. Roe had to go through all that, and we didn't know really what to do. It's like, wow, this is really going. You could see they weren't following the law, but what do you do about it? Well, let's complain to the chief judge, right? Finally, December, let's complain to the chief judge. And this isn't really that well written, but as I remember at the time, there was lots going on, and just trying to jam something out to see what we could do. So, forgive my grammatical errors. Forgive me. I'm not sure of your lawful title. It appears on ARDC that Judith Mary Brokaw is a full licensed name of an individual attorney authorized to practice law in Illinois, who is now also holding the office of Chief Judge of a judicial circuit under the assumed name Judith M. Brokaw. And there you are. This is part of the thing. See, for her, she does have her full name, full legal name, Judith Mary Brokaw, on this ARDC, which is the Attorney Registration and Disciplinary Commission website for Illinois. But most attorneys don't have this name. They have like this with a middle initial. And sure enough, as a judge, that is how she's using her name, Judith M. Brokaw. Well, I thought she was Judith Mary Brokaw. You can't be both. Right? One is her full legal name, and the other one is a pseudonym. Fictitious name, nickname, unregistered alias, but not the name that she said she was an attorney with, which is Judith Mary Brokaw. And in Illinois, to be a judge, well, you got to be an attorney. So she would have to be a judge in the name Judith Mary Brokaw. Yet, it says she's a judge in the name Judith M. Brokaw. Is it unlawful to hold two public offices under different names? Because a licensed attorney is an officer of the court. Well, so is a judge. Those are two different offices. Is it lawful to hold two public offices under different names? How is it that Judith M. Brokaw, who was never an attorney and could never have been elected or appointed a judge, have you vacated your office or merely usurped his powers? Nevertheless, you and those like you participate in a conference of chief circuit judges. Among other things, this conference approves the forms used in the circuit courts of Illinois. Further, it appears you have been appointed to govern the courts and practice law by rules of your private society within a defined territory, namely the 16th Judicial Circuit of the Circuit Court of Illinois. I'm sorry to have to inform you that your subordinate officers of court, fellow members of your private society, bound by your rules, are habitually using unapproved forms in your court, rendering the proceedings not only illegitimate, and it is an indirect criminal contempt of court, but also nothing less than an international crime against humanity. According to Illinois Supreme Court Rule 552, in pertinent part, uniform citation and complaint forms and conservation complaints shall be in forms which may from time to time be approved by the Conference of Chief Circuit Judges and filed with this court. The uniform forms shall be adapted for use by municipalities. I'm providing you documentary evidence of an unapproved uniform citation and complaint form that was filed in your court under Gen number 13-17026. See Exhibit A. The use of this unapproved uniform citation and complaint form is in direct criminal contempt of the Illinois Supreme Court, and the officers involved have brought fraud upon said court by participating in official misconduct and false impersonation of a public officer. It is the will of the Lord that you make them stop now. I wonder if it's because I brought God into the picture. Shit, that's the same one. Page 2. The use of color law and simulated legal process is a civil rights violation, and the enforced disappearance of my proper person is considered enslavement. I believe Gen number 13-17206 is a simulated legal process using color of law, as is the unapproved bail bond form that they call a certificate of defendant, that would be Exhibit B, and the unapproved arrest warrant. Article 8, Illinois Rules of Professional Conduct, Rule 5.5, Unauthorized Practice of Law, Multi-Jurisdictional Practice of Law, and Rule 8.3, Reporting Professional Misconduct, taken together, make it dereliction of duty for one Judith Mary Brokaw, authorized attorney and counselor at law, not to prosecute these violators. So what I pointed out to her is, hey, you say you're an attorney under this, your full legal name. Well, in your manual for attorneys under unauthorized practice of law, she would have a duty to point this out. As captain of the ship, you, Judith Mary Brokaw, are responsible for the behavior, for their behavior, and it is the will of the Lord that you make them stop now. Judith Mary Brokaw, why do you persecute me? I have provided you evidence of my citizenship in the kingdom of heaven in the form of my baptismal certificate. I do not consent to a presumed jurisdiction over my property or myself. I do demand you enforce your private society's laws over those who have freely consented to your jurisdiction. If you somehow feel you have lawful authority over me, then you must immediately inform the Vatican City State of my request that they represent me in this matter. I appeal to the Sovereign Pontiff Francis I. I see that he is informed. For the record, I'm an immortal spirit, child of God. Here is one of his people who has chosen a state of life as a citizen of the Holy See and freely given the Catholic Church in personam jurisdiction over my persons. Rosita. That's what we told him. Now you can say what you want about the Catholic Church. That's your opinion. This is what the judge said. So that was on the 10th. So here on December 15th, in this case between the people of the state of Illinois versus Rosita, 13 CM 3431, there was an order issued that said, this cause coming on for administrative review of ex parte correspondence concerning the above numbered cases, dated December 10, 2014, addressed to the attention of the undersigned Chief Judge, and received on December 12, 2014, said review conducted pursuant to policy and procedure, this court having reviewed the correspondence and the court file, finds the defendant having been found unfit on October 28, 2014, that the ex parte correspondence dated the 10th of 2014 is relevant on the issue of the defendant's fitness and on the issues of court security. That's interesting. On the issue of court security. Tick, 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 tick. Security usually means a bond. Wherefore, it is hereby ordered, the clerk of the court shall file the ex parte correspondence dated the 10th of December 2014 and attach to this order as Exhibit A in the court file herein. 2. The clerk of the court shall send a file stamped copy of this order and attach the Exhibit A to the Department of Human Services, Kane County State Attorney, Defendant Straskavine, Kane County Defender, Acting Director, Sheriff Secretary. So anyways, hey, this is what the Chief Judge did. She got the letter on the 12th, and by the 15th, she had filed it herself into the court case. We never sent this to the court case. The judge put it in the court case. And she wasn't quite done. Then they ended up subpoenaing Dr. Ray Kim, who was supposed to be the clinical psychologist, and they had appointed to Roe's case, because they hadn't really followed the rules. But anyways, hey, they subpoenaed the doctor, and they issued an order. What date is this? Let's see. On 1/28/15, so, some weeks later, matter comes to court on a motion for discharge hearing based on PA 98-1025. Court grants a motion. Matter continued to 3/18/2015, 1 p.m. at KBC for discharge hearing. So see, it says we're going to have a discharge hearing at on 3/18/2015 at 1 p.m. Well, something's happening. And then Sandy, who was the lady that originally filed the complaint, well, she gets this, a notice to appear. And I just point out here that they use the beginning gen number for the first time. Usually they call it case number. Now it's gen number. And she was told to show up at 12:45, which is 15 minutes before the hearing. That's supposed to happen at 1 o'clock. So this is a different hearing. Her notice to appear is for a different court case. Well, sure it is. Gen number 13CM, 3431. So anyways, they did this, and on this particular day, Rose in court, and this dog and pony show goes on from 1 o'clock till, I don't know, she had a couple hours, man. So it was quite humorous. But one of the things is when Sandy showed up and had to take the stand, Sandy didn't look so good. Sandy looked like she'd been scared quite bad, and she was really afraid of what to say and so forth and so on, and they dribbled their way through the court or through the proceedings. Until they get all done, and on that day, Judge Teagler wrote that matter comes before the court for discharge hearing. State amends motion to amend complaint is granted. State's motion to admit prior bad acts is granted over defendants, they didn't say defendant, over D's objections. I'm not going to say who it is. Matter proceeds to hearing. State calls Kelly, Linda, Sandy. State rests. Motion for directed finding is delivered. Exhibit 1 and Exhibit 3 is admitted into evidence. After argument, court enters a not guilty finding. According to 720 ILCS 5/104-25, court finds 30 days have passed. Blank to be released. Right? They don't put any name. Now Rosita is represented by a pyramid. Right? Three-sided pyramid. To be released pursuant to 720 ILCS 5/104, whatever the fuck that is there in the corner. All bond money to be returned to D. Case closed. That's how they got rid of it. That was on 3/30/2015. And so up until this point, Roe was, headed to jail time and all sorts of stuff. And sure enough, here's a bond refund amount, Kane County Circuit Court. And all of this stuff is interesting on its own because, see here they have the amount with a peso sign, 575, right? But nowhere on here does it say the word dollars. Right, 575 and 00, but it doesn't say dollars. We pointed that out to them, and they gave some snarky answer of some kind. But, all right, so I don't know what to make of that. It started out here. I mean, we're talking some length of time because this was September 4th, 2013. And we're going into 2015. March of 2015 before this thing finally goes away. But things we found out along the way was that, this Kenneth J. Sison, who said he's a frickin' a notary, is actually a detective or a sergeant or something at the sheriff's department, and he hasn't had a notary for 10 years. They still have him doing paperwork as a notary. I'd say that's corruption. This disorderly conduct, this is really, if they're just going to call it disorderly conduct, that would be like an ordinance violation. And we had looked at Batavia, which was a town right next to Geneva. And in Batavia, they have a fine for disorderly conduct. It's like $25 as an ordinance violation. And yet this thing had been pumped up to a $3,000, actually I think it got up to $5,000 bond or something like that. And what they did is they got Roe. They used this bullshit piece of paper under this gen number to get to this bullshit piece of paper that doesn't even have a court case. No, it doesn't say gen number. Now it's a case number. That's a bond upon which Rosita is agreeing that she owes these people called People of Illinois $1,200. Not the people in the state of Illinois, like the plaintiff. No, somebody called the People of Illinois. So that was that case, right? I wouldn't write all that stuff I'd written before, but that's what I wrote that time. Well, then just here recently, something that started out with a ticket that looked like this on a state of Michigan uniform law citation at or near the South County line in Clam Lake Township, Wexford County. Somebody found a controlled substance, possession of marijuana. Is this the one where they use the H? Marijuana? 333.7403, which that isn't anything. We'll get into that in a minute. And Glock 17 on rear seat with loaded mag and unlocked case with a passenger who had the same thing. So in this case, two individuals coming back from camping with kayaks on top of their car and their camping gear packed into backpacks thrown in the back seat of the car, within which in each case was an unloaded Glock or handgun and bullets in a magazine, but not in the gun, just in the bag. Well, that was enough to be considered, basically concealed weapons. To have broken the law. Possibly. Although these guys end up leaving and coming home, and it's only later does the shenanigans happen, but this was done by the Michigan State Police. Edward Ricklefs, who decided to be a satanic sock puppet for an attorney who's pretending to be a prosecutor. And so we got this case number here, 7064. So this was the initiating document. Now, just a couple of things, real quick. This 333.7403. If this was a Michigan compiled law, this particular one with the H is for medical marijuana and is enforceable by a public health officer, not a police officer. And it has a sentence of up to 1 year. And because of that, you would have to, in Michigan, you can only use this form here for misdemeanors up to 91 days. Any more than 91 days, you have to actually fill out a misdemeanor complaint form. And, there wasn't anything about a handgun. It was just a remark. Although they did take the handguns, right? But they didn't charge them with anything. In this citation, this offense code, 3462, is some national database code, right? These aren't laws of Michigan. That's my point. All right, this guy who's supposed to be, claims to be a Michigan State Police officer, isn't charging anybody with breaking any laws of Michigan. Because if this was going to be a Michigan compiled law, it would have to say MCL 3337403. It would have to say here that they broke a state law. And then spell out what the law is. Right? What's the offense? So that was that piece of paper. Well, one of the things that thing's generated was this right here that said complaint felony. Right? Although it doesn't have a court case number, pay attention to that. But there's the number on the ticket, 00M70 764-16, and it does have some case number, but it doesn't say district or circuit. So I'm just saying, this is what they're saying is a complaint carrying a concealed weapon. The complaining witness, Trooper Mark Moore, says on or about some date in Clam Township, Wexford County, Michigan, the defendant, contrary to law, did something. Now, Trooper Mark Moore isn't the trooper on the ticket. That was Edward Rickliffs. So there was only one trooper there, and Trooper Mark Moore wasn't one of them. Wasn't the one that was. Yet he's the complaining witness. What happened? Did carry a dangerous weapon, to wit, a pistol. Whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a 2003 Mitsubishi, contrary to MCL 750-227. Well, that would be a penal code violation. It's a felony, 5 years, or $2,500, mandatory forfeiture of weapons or device, see MCL 750-239. And a controlled substance, possession of marijuana. Now this time they're using the J. But in the other one, they're using an H. Intentionally controlled substance, marijuana, contrary to MCL, something or other. Right? See here, it's MCL 333, whatever. And here, they put it in without the MCL 333. A different format. And it says, upon conviction of a felony or attempted felony, court shall order law enforcement to collect DNA identification profiling samples. Now we get to the good part. The complaining witness ask. Again, the complaining witness is an officer who wasn't there. The defendant be apprehended and dealt with according to law. Peace officers only. I declare the statements above are true to the best of my information, knowledge, and belief. Well, as we can see, nobody ever signed the damn complaint. And yet, it was allowed, a warrant was authorized by Thomas G. Troutner, who's an assistant prosecutor in Wexford County. He authorized a warrant even though the complaining witness, who had never been there, didn't sign the damn complaint. And this is what they were going to use in court as a felony. Well, that didn't go so well. And just some of the other pieces of paper that they issued, right, is this felony adult bindover, people of the state of Michigan. Now again, we saw before that in Michigan, it will be in the name of the people of the state of Michigan, not people of the state of Michigan. Where is that? Style of. In the name of the people of the state of Michigan. That's in courts of record, courts that have seals. Well, this has people of the state of Michigan, so guess what? This court doesn't have a seal. Then you're really not in court, and you're being kept from going to the court that does have a seal, and that would be a violation of your habeas corpus protections. Unless we're under martial law. And if we are, well, then we need to go to the military. See how it all fits together? But this is the bullshit paper they had in this court case. Look, there's nobody signed it. All these errors and omissions. Blank, 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 blank. This is what they gave the defendants for the, this is what they're going to court with. This kind of fucking paperwork. It's like, holy smokes. How are you going to argue with that stuff? Well, as it turned out, let's look. So, What they should have done, because this had a misdemeanor that was more than 91 days, there should be one of these. Right? The people of the state of Michigan. Is that what it said to do? Shoot, I should keep that open, because I can never remember. In the name of the people of the state of Michigan. So I don't know. I don't see any place where it says in the name of the state of Michigan. But anyways, they're supposed to fill one of these out. This is what the prosecuting attorney should have signed. And this is for a misdemeanor of more than 91 days, which the misdemeanor they were charged with was more than 91 days, so they couldn't use the ticket as the charging instrument. They would have to fill out this form here. But they didn't. And okay, and there was also, it was like they're being charged in the district court and the circuit court at the same time, which I don't really understand. But here was the bond. So here was the bond for this case. Right? Offenses, weapons, possession of MJ. That's the frickin' offense. There is no offense named that. Right? The people of the state of Michigan. Look at all these blanks. No firearms, right? Conditions of the bond, no firearms. But it was never accepted. Right? This is just errors and omissions on top. They're not even trying. They're hardly even pretending to be doing it right. And if they had done a felony complaint, which they did say they did, I mean, that's what, where's that thing at? That's what this thing says it is. This says it's a complaint felony. Well, in Michigan, they have a packet of papers, and this is the complaint felony that they're supposed to use. But before they get there, it was supposed to have this information filled out. This is like a 5-page packet that goes together that you would use to open a felony case. And the first one's the information. And so this is what the informant, the person that saw it, would fill out. And take it to the prosecuting attorney. And from that, they would investigate, and then this complaint would be filled out, because now the victim is the complainant, but the complainant witness is the person that you're telling the story to. And so that could be an officer, but he's doing it based on the fact that somebody had already filled in one of these, and they never did show this. And so the whole thing is a simulated legal process under color of law. Blah 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 blah. What else did we have? Here's Michigan State Department of State Police original incident report. Michigan State Police, CCW pistols and vehicles, possession of marijuana with a J. Okay, there's our incident number, although I don't know what the HT is for. I don't know what any of these things mean, but the state police say it's in Wexford County. In fact, what do the state police say? Venue, Wexford County, Clam Lake Township. Southbound US 131 highway at or near South County line. But, right, this hadn't been investigated by anybody, and it hadn't been reviewed by anybody. It just been reported by a scribble. And, just to show you some of the papers that were put in. And so what did we do? Well, so I wrote this. Robert Allen, Michael Rutluski, Son of God, Relator for my Lord the Christ Jesus. To Honorable William N. Fagerman, Chief Judge. Yada yada. Complaint, violation of the common law of the church, Michigan Penal Code, Michigan Court Rules, 1985, and unwarranted persecution of alleged defendant and friend by those you control. Chief Judge Fagerman, this relation is to enlighten your conscience to the persecution of the children of God. In the trial courts, you have been assigned superintending control. Your judicial officers, clerical staff, and attorneys at law do not abide by their promise to God, do not act in conformity with the Michigan court rules, administrative orders of the Supreme Court of Michigan, compiled laws, rules of professional conduct, or the law of God. Further, the Michigan State Police are impersonating law enforcement officers of State of Michigan and violate the Michigan Penal Code in every improperly executed State of Michigan uniform law citation that bears false witness against their brothers. In other words, if you say that you're a frickin' state cop in Michigan and you think that you're going to be allowed to issue this kind of bullshit anymore, and, get whatever your fucking fee is under the table, that ain't happening no more. We're going to put an end to this. Please stop doing it. I don't have anything against a man in uniform. I wore one myself. 8 years. 8 years in the Army. But I ain't putting up with it. I just don't really know what to do about it yet, and I'm going to do it peacefully, but I'm going to find the answer, and I'm going to go get the hammer and have them use it on you. I just assume they used it on the attorneys, right? Just stand outside. Go arrest them, and this could all be done. If you guys in blue would just turn around and walk back into the frickin' courtroom and put the judge in handcuffs with those attorneys and put them in a holding cell, this would all take care of itself in no time whatsoever. Until then, you're going to have to... You're on the front line. That's all I can tell you. You need to make a decision first. Ticket number X2009494, incident number 7D76416, case number 7D76416, is but one example of a RICO-type conspiracy happening on your watch. This simulated legal process against the alleged defendant is a sin against God. Alleged defendant 2, longtime friend and fellow traveler with alleged defendant, as stated in the unauthorized legal process, is likewise persecuted under similar documentary evidence of perjury. Obviously, I've taken the people's names out to protect the innocent. The uniform law citation has been signed by a peace officer, does not list any state law offended, gives no motor vehicle code violation, local ordinance, or admin rule as reason for endangering the lives of the public during unwarranted stopping and arresting of 2 of God's children. And so the reason the cop stopped them, apparently, is because their muffler made too much noise. But it's not written anywhere on the ticket as the reason for being stopped. The alleged officer, a.k.a. Edward Rickfells, confiscated private property, did not sign his complaint, and apparently did not file a DC 225 complaint misdemeanor for 333-7403, a quasi-public health code violation. His actions are larceny and an act of conspiracy in a simulated legal process done under color of law. Man, do you really want to be involved in shit like that? The same being a federal criminal civil rights violation, which you have a duty to prosecute in accordance with Article 6 and the 14th Amendment of the Constitution of the United States. That would be the duties of the judge. Equal protection of the law. This uniform law citation has generated numerous alleged court case numbers, including, and this is the thing, this one piece of paper created all these different cases under different numbers. So one was 00M70-76416, another was 2016 001146, that was in the 28th Judicial Circuit, Another was 162918FY, and another was 1629FY-1. So a couple of these appear on an instrument claiming to be a complaint felony that is not on a scale. That would be the State Court Administrator Office approved form. They didn't use the approved form to do the paperwork. And has not been signed by a complainant witness attested by a judge. Thomas J. Troutner, unregistered alias of P41826, has simulated the authorization of a warrant. Unless Thomas G. Troutner is enrolled in the official roll of attorneys maintained by the Supreme Court clerk, he is in criminal contempt of the Supreme Court. Please investigate. These instruments have not been filed by the clerk. Just tick, 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 on and on and on to all the shit they did wrong. Oh, how did I do that? Then we had some more. This other form appears to be an outdated State Court Administrator bond, which it was not accepted by a court officer. Remember, it didn't have a signature at the bottom. We had another one appeared to be two separate notice to appear forms, neither of which are on the approved MC06 form. So they're using forms that say notice to appear, but they're not the forms that have been approved by the State Court Administrator's Office. There is no address for the plaintiff, no courtroom specified for said appearance, no state law, ordinance, admin rule listed as offenses. They do not list attorney firm hired by an alleged defendant, error not properly signed, yada, yada, yada. And then Rule 6.101. This is in criminal procedures. The complaint, right? This, when you're talking criminal, it all starts with a complaint. Definition and form. A complaint is a written accusation that a named or described person has committed a specific criminal offense. The complaint must include the substance of the accusation against the accused and the name and statutory citation of the offense. That would be out of the Michigan Penal Code. Signature and oath. The complaint must be signed and sworn before a judicial officer or court clerk. Prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. Finally, alleged defendant hired some law firm to do their stuff, and, they didn't do it. So, yada, yada, yada. That's what this one was like. And I wouldn't do either of them the way I did it again. I just said, all I did is point out the things that are wrong with the paper. And blah, blah, blah my way through it. But to show you that complaint one more time, because I may have forgot to really point this out, that here, right, the complaining witness has to sign, and so does a judge with his bar card. On information and belief, warrant authorized by. So how can Thomas G. Troutner authorize a warrant when a complaining witness and a judge haven't said there was any complaint? I just seems to think they're not doing it quite right. All that was what happened, and here just recently, this is what happened. Motion order of noli prosequi. What does that mean? It means that Thomas G. Troutner, right, the guy that signed the complaint as the assistant prosecutor, even though a complaining witness nor judge had signed it, now he's going to say prosecuting official moves for a nolle prosequi in this case. Following reasons. Defendant charged in wrong county. Proper venue is Osceola County. And there's old Thomas again. I should check to see if this is the same bar number. I'll say it is. That was on 11/3/2016. And so it is ordered. Motion for nolle prosequi granted, and the case is dismissed without prejudice. This says it's a true copy. I've never seen that before on something. Wexford County Clerk. Wexford County Clerk, not clerk of Wexford County, but the Wexford County Clerk. But it doesn't have anything from the deputy. So, again, they're still simulating the legal process, right? But it just seems like they don't want to go any further with this case. Signed by the judge. And that's where it sits today. And so, in this case, one of the defendants had hired an attorney, and the other one was using a public defender. And the one using the public defender had actually already agreed to a plea deal that had jail time involved. I just don't remember how much. But when this happened, he got a call from his public defender saying, hey, there's been a change in your case, and, well, you won't have to go to jail after all. Right? They're dropping the case. So they can say that they did it for whatever reason they want. I don't really care at this point. All I'm saying is, hey, they let this go. Now, the strange thing is, when you look at this, is that, look at it again real quick. This all happened here on 11/3/2016. And that letter I sent was, that was back in July 2016. That was really the last thing I did in the court case, other than to the court. I did send some things to the State Court Administrator's Office. I sent some things to State Police Post, but that was actually before this. But I had been pretty much done, and I was just saying, well, what am I going to do next? And was really waiting to see what the attorney came up with, and was giving things to the defendant to give to his attorney to have him look into, and so forth and so on. But one of the things I know is that the attorney that had been hired had actually won the election to become the prosecutor. And that would have been happening any time now, where he would have gone into office as the prosecutor. And, this November 4th date is right around the date of the election and so forth. And although for the prosecutor, it had already been determined, but these are for the other offices. And so I don't know what happened, right? I don't think he wanted to have that on his plate when he got there, because he had been given all this information. He knows what's going on, and he wanted it to go away. And this is how they're going to make it go away, by hiding the truth and trying to bury it in some dismissal. So we'll see what we do next. But so my point was, okay, well, having done it that way in two cases, then we can agree or disagree that sending something to the chief judge got the cases dismissed, but we're going to have to say in both cases the cases were dismissed because, hey, they said the cases are dismissed. So what would I do today, right? So, well, like I said, I would try to use this form here. And maybe these words here, just as soon as it loads up. Come on. Okay. So, don't hold me to this exactly, because I don't know that this is what I will do exactly, but it will be something like this. I'm quite sure. Is on the sworn statement form. Wording more like this, right? It is my belief that this is somebody writing it for themselves into their own court case. It is my belief I am the victim of a simulated legal process that uses color of law as part of a scheme to coerce my consent to the extortion of my private property and alleged voluntary servitude of my person by individuals under your immediate administrative control. Full legal name of the court is concealed. No seal of a court of record is evident. Alleged officers of the court represent themselves by pseudonym instead of their full legal name. Alleged documents they submit have omissions that simulate a legal process are intended to obstruct justice. This lack of use of court seals evidences that habeas corpus has been suspended and that the country is under martial law, or that insurgents have usurped the offices of civil authorities, are engaged in war crimes. In violation of the Labor Code, martial law, and Constitution of the United States civil protections, your subordinates are using the courts you have superintending control over and their civil office for private gain, in violation of their appointment and oath of office. Alternatively, their behavior could be construed to be that of belligerents in an ongoing rebellion. I demand an investigation into this wrongdoing, the return of my private property associated with this case, including the face value of any negotiable instruments created as part of a scheme paid to me in legal tender, the restoration of my sui juris legal status, and the prosecution of wrongdoers. So some version of these words, or something with this kind of idea, whatever you want to use, on this sworn statement form, send it to the chief judge. Go ahead and put it in your court case as far as that goes. Fucking A, go put it in your court case and send it to the chief judge. But send it to the chief judge. Make him responsible. I'd put his name in here. I'd put, his name, his title, whatever, because it's your sworn statement. So you go ahead and swear to it. I said it. Absolutely I did. And you go and you take it to somebody that is authorized by law to administer oaths and have them do their thing with witnesses involved. Well, right? Let every word be established by 2 or 3 witnesses. And if the court won't do something with it, then take it down to the armory. Right? And I'd put that in here. I said, well, if you don't do something with it, my only recourse will be to take it directly to the military and have you arrested. And tell the chief judge you're going to have his ass arrested. And see if that does anything. And so, instead of just a piece of paper, it will be a sworn statement, and I'm going to use this form, and I'm going to send it to some chief judge for something somewhere and see if he does something with it, and if not, well, I'll take it to the Army and see if they do something with it. But, if you're looking for an idea, the things to point out, we'll stop the screen and read this real close, real slow, and there you are. So, okay, I don't know what else to make of that other than, I'm a firm believer that we're still under martial law because it was. Oh, that's all I wanted to read. One last thing. We got time. Revoking civil liberties, Lincoln's constitutional dilemma. His suspension of habeas corpus is part of what some consider the dark side of his presidency. This was written by Justin Ewers, staff writer, on February 10th, 2009. I don't remember what I found it in, but you could Google Revoking Civil Liberties, Lincoln's Constitutional Dilemma, and man, Google will take you right to it. So, few presidents have interpreted their wartime powers as broadly as Abraham Lincoln. What powers wartime powers, whose presidency, for all of its many successes, did have what some consider a dark side. Most famously, Lincoln suspended the writ of habeas corpus in the first year of the Civil War, responding to riots and local militia actions in the border states by allowing the indefinite detention of loyal persons or disloyal persons without trial. So for myself, well, you can't call me disloyal, brother. I took an oath. I have saluted the flag. Habeas corpus, which literally means you have the body, is a constitutional mandate requiring the government to give prisoners access to courts. Well, if they're not using a court seal, you ain't made it to court. And they don't use a court seal. Lincoln ignored Supreme Court Justice's decision overturning his order, and over the next few years, the great emancipator, in one of the war's starkest ironies, allowed these new restrictions, which also imposed martial law in some volatile border areas and curbed freedom of speech and press, to expand throughout the northern states. As the war drew to a close, though, some historians believe Lincoln may have begun to recognize the danger of his own unprecedented expansion of presidential war powers. More than 13,000 civilians were arrested under martial law during the war throughout the Union. But it was in Missouri in particular, nearly 1,000 miles from the nation's capital and far beyond the federal government's day-to-day reach, that Lincoln was confronted with the most drastic example of his internal security measures' unintended consequences. In the months before he was assassinated, Lincoln found, to his surprise, that he was unable to convince Missouri Republican leaders, who had grown accustomed to their newfound powers, to put an end to martial law in the state. The lesson he learned, historians say, have been a simple one. It's much easier, some professors said, to put these restrictions in place than to stop them. In other words, you let the genie out of the bottle and you can't get the genie back in. Let's read that again. In the months before he was assassinated, Lincoln found, to his surprise, that he was unable to convince Missouri's Republican leaders, who had grown accustomed to their newfound powers, to put an end to martial law in the state. When the war started, there was little doubt in Lincoln's mind that his suspension of civil liberties was both necessary and constitutional. His political opponents may have disagreed, but facing a full-fledged insurrection in the South, and with the loyalty of Maryland, the state between Washington, D.C. and the rest of the Union, wavering, Lincoln had grounds to worry that the nation's capital was in real danger. His worst fears were realized in the first months of the war, when a group of Massachusetts soldiers he had ordered south to protect the capital was attacked by an angry mob as the troops passed through Baltimore. The soldiers, panicking, fired into the crowd, killing 12 civilians. 4 soldiers were killed, too. Ironically, they were the first casualties of the Civil War. With Southern sympathizers beginning to cut telegraph wires and burn bridges behind Union lines in Maryland, Lincoln gave the order in April 1861 to suspend the writ of habeas corpus, allowing the Army to arrest and detain without trial those considered disloyal. His order was limited to the rail lines between D.C. and Philadelphia, but soon spread to the rest of the Union. Legally, Lincoln felt he was on firm ground. The Constitution, after all, explicitly grants the government the power to suspend habeas corpus in case of rebellion or invasion, though it's not clear whether this power resides with the Congress or the President. In either case, before the war was over, the Union would face both rebellion and invasion. In 1863, Congress passed a law, the Habeas Corpus Indemnity Act, in support of Lincoln. Though he was worried privately that these new powers might be misused, Lincoln publicly scoffed at the notions of his administration's suspension of civil liberties would have any long-term consequences. In a letter published before 1864 election, Lincoln compared the wartime measures to the bitter medicine a patient takes when he is sick. He could not believe, he wrote, that the American people will, by means of military arrest during the rebellion, lose the right of public discussion, the liberty of speech and press, the law of evidence and trial of jury, and habeas corpus throughout an indefinite peaceful future. Any more than I am able to believe that man could contract so strong an appetite for emetics, medicines, during a temporary illness as to persist in feeding upon them through the remainder of his healthy life. Well, he's never heard of Oxycontin. Apparently that shit can happen. The American people will, by means of military arrest during the rebellion, lose the right of public discussion, the liberty of speech and the press, the law of evidence, trial by jury, and habeas corpus throughout the indefinite, peaceful future. That's exactly what's going on, because we're still under martial law. When Lincoln wrote these words, though, some historians argue he may not have realized just how far things had gone in Missouri. Martial law was declared early in the war in the frontier states, which set thousands of men to fight for both sides in the Civil War. With the population sharply divided on issues of slavery, the state was riddled throughout the war by hundreds of small skirmishes, many of them involving neighbors fighting neighbors and guerrilla bands torching farms and crops. The military government, meanwhile, struggled to maintain order. Nearly half of the military trials conducted in the Union during the war took place in Missouri, 9 times as many as in Kentucky or Maryland, 2 other volatile border states. In 1863, after one particularly brutal massacre, in which rebel guerrillas slaughtered more than 100 pro-Union civilians in Lawrence, Kansas, the local army commander evicted 20,000 civilians from border counties in Missouri, some of whom he believed may have been sheltering the rebels. It was, writes Mark Neely, a professor of history at Penn State University, in Our Lincoln, New Perspectives of Lincoln and His World, the most drastic displacement of population of its kind in the whole Civil War. Lincoln was certainly aware of the measures being taken in his administration's name, but it was only after the 1864 elections which he felt he could do something about them. Lincoln had tried to persuade the military commander in the area to consider ending martial law early in the war, but he had been rebuffed. The peace of the state rests on military power, the officer had replied. To relinquish this power would be dangerous. As the war began to wind down and the threat of Confederate invasion dwindled, Lincoln decided to try again. In the fall of 1864, after he had won re-election, Lincoln appealed to the general in control of the state to repeal martial law. Please gather information, he wrote, and consider whether an appeal to the people there to go to their homes and let one another alone may not allow you to withdraw your troops. What Lincoln didn't realize, scholars say, was just how much fierce fighting in Missouri had hardened attitudes there and how much the leaders of Lincoln's own party had grown accustomed to the status quo, to having the power. Right? Because what they need to do is a proclamation telling everybody to go home and cease and desist. And then we'll remove the troops. That would be the proclamation that hasn't been issued yet. The first signs of trouble appeared in the state election results. More than 165,000 Missourians had voted in the 1860 presidential election, with only 17,000 votes in support of Lincoln. But 4 years later, Lincoln had received 70% of just over 100,000 votes cast. The question, of course, was just not how Lincoln had grown so popular, but what had happened to the rest of the voters, because there had been 165,000, and now there's only 100,000. Essentially, writes Neely, much of the Democratic Party in elections in Missouri, likely a majority, had disappeared. Oh. I think somebody was out culling the herd. Neely, for one, believes Lincoln probably understood what had happened. The state's Republicans had used their newfound war powers not just to shut down newspapers and arrest those they considered disloyal, but to intimidate and disenfranchise the Democrats, many of whom supported slavery, and some of whom were sympathetic to the Confederacy. The Republicans, in other words, reigned supreme in Missouri. They had the army at their backs, and they liked it that way. what Lincoln had attempted to guard against in his internal security policy had come to pass. Lincoln's appeal at the end of March to end martial law fell on deaf ears. "Allow me to assure you," replied General Grenville Dodge, the newly appointed military commander in the area, when he received Lincoln's suggestion that martial law be repealed, "that the course you propose would be protested against by the state authorities, the legislature, the Constitutional Convention, and by nearly every undoubtedly loyal man in northern Missouri." Stymied, Lincoln turned instead to the state's new governor, Thomas Fletcher. It seemed there is now no organized force of enemy in Missouri, and yet the destruction of property and life is rampant everywhere, Lincoln wrote. "Is not a cure for this within easy reach of the people themselves? It cannot but be that every man, not naturally a robber or cutthroat, would gladly put an end to this state of things." Lincoln asked Fletcher to call for neighborhood meetings so preparations could be made to end martial law. At such meetings, Lincoln said, hopefully old friendships will cross the memory and honor and Christian charity will come in to help. To Lincoln's surprise, the governor, too, refused him. "It would madden the true men of the state," Fletcher wrote, "to talk to them of reliance, of honor, and Christian charity, of these fiends in human shapes." It was at this moment, historians believe, that Lincoln may have realized how far his civil liberties restrictions had been taken and how difficult it might prove to restore those liberties. "Governments that assemble these powers tend to be rather reluctant to give them up," says Foner, "particularly, it seems, during a violent, highly personal civil war." Lincoln had miscalculated. He could not at first believe that liberty could permanently diminish among the liberty-loving American people, writes Neely. Missouri was proving him wrong. Lincoln's solution was straightforward. If neither the Army commander in Missouri or the civilian leaders would agree to end martial law, Lincoln would send in the Army to do it for them. Of course, the Army's already there, so what are you going to do? Only a few months before he was killed, Lincoln decided to send a new general, John Pope, to the state to impose his will. Pope, to his surprise, found the rancor in Missouri went even deeper than Lincoln imagined. In March 1865, a newspaper correspondent in St. Louis reported that many Republicans in Missouri, not just the state's leader, had come to admire the efficiency of martial law. So far from being unpopular, it is believed that a large portion of our loyal people are willing to see a provision incorporated in the charter of the city requiring 6 months of martial law to be imposed every 5 years to clean up the little cases of outraged justice, loose indictments, public corruption, and private peculation which the ordinary courts cannot reach. Lincoln's envoy pushed back against what he and the president surely recognized as creeping tyranny. Pope reminded the state's leaders that he fully believed in the capacity of the American people for self-government. In a letter to the governor, Pope and he already had an alarming and fatal tendency. Pope said he already had seen an alarming and fatal tendency among the people to surrender to the military the execution of the laws, and thus abandon all safeguards against tyranny and oppression. He worried about whether or where this temptation might lead. Once the American people abandon themselves to this practice, which indulgence confirms into a habit, and their liberties are gone from them forever. There is little evidence, unfortunately, of what Lincoln thought of these final developments. He was killed only a few weeks later, before martial law was finally repealed in Missouri, and before civil liberties could be restored elsewhere in the country. It seems likely, though, that in the waning months of the war, Lincoln learned an important lesson. Civil liberties are much more difficult to restore than to revoke. And so, are we under martial law? I don't know. You go and find the proclamation or the peace treaty that says that it's been repealed, then it has been. Until you do, well, then we are still under martial law. Habeas corpus has been revoked, and I say the simplest evidence of that is just go look at a court case. They never use a court seal. Your city never uses a seal. The county never uses a seal. The township never uses a seal. Nobody uses a seal. All their functions have been suspended, and we only have people acting. They're de facto actors, acting like they're in those offices, all using pseudonyms, fictitious names, all having had taken oath, just not the oath that it says to take in the law for that particular office, but they have taken an oath, and they've taken it in their fictitious name, and so be it. Well, I say that oath is to the military, and that they are under the authority of the military. Blah, 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 blah. Okay, well, I'm going to leave it there, and like I said, it can't hurt to try to send something to the chief judge. I can show you 2 cases where cases have been dismissed, where one of the many things done was sending it to the chief judge, complaining that what you're involved in is a simulated legal process. And I'll get more into this on another video. I just wanted to get this out of the way today so I can go do a video on what the form will look like in the next one that I do once I think about what it's going to be. So until then, y'all have a great day. We'll see ya.